The Iowa Supreme Court has tossed out a lawsuit claiming the state failed to protect Iowans' rights to clean drinking water. The suit claimed farmers upstream were polluting the Raccoon River, which is a source of drinking water for hundreds of thousands of people who live in the metro. WHO 13's Roger Riley joins us live right now with the court's decision and what comes next. Roger.
Yeah, Dan, you know, this case is about clean water and something called the public trust. And the groups filing the suit have, whether or not they have standing. Also in this case is a separation of powers between branches of government. Now, this was the plaintiff's case is that Iowa CCI and Food and Water Watch invoking the public trust doctrine that the state has abdicated to control parts of the Raccoon River by allowing nitrogen and phosphorus control strategy to be voluntary. The suit calls to strike down that law passed by the legislature, Section 20 of Senate 512, which gives people the authority to do a voluntary nutrient reduction strategy. The court opinion addressed the public trust doctrine. Now, historically in Iowa, the public trust doctrine has not provided an opening for courts to weigh different uses, that is, to second-guess regulatory decisions made by elected bodies. The majority opinion wrote, "The suggestion is made that this court could simply tell our legislature to pass laws that would bring nitrate levels in the Raccoon River consistently below 10 milligrams per liter. That's a specific outcome. There are no judicially discoverable and manageable standards to aid a court in deciding whether that outcome is better than any other outcome." As to legal standing, the court wrote, "For there to be standing in a federal court, a plaintiff must show not only injury in fact, but also that the injury in fact is fairly traceable to the defendant's conduct and is likely to be redressed by a favorable decision. We agree, therefore, and conclude that standing is absent in this case." Now, the court also raised the issue of separation of powers. In effect, the judiciary would be exercising a veto power over the legislature. At this point, we would cease to be a co-equal branch of government. Instead, we'd be asserting superiority. Now, in a dissenting opinion, Justice Apple wrote, "In particular, I would refuse to allow hand-wringing application of standing doctrine to throttle environmental litigation in a motion to dismiss." Now, I talked to Adam Mason from Iowa CCI. He said they are not giving up.
We are disappointed by the ruling today. We are taking comfort and I think finding a silver lining in the fact that it was a very close split decision. The 4-3 vote, we're still going through the ruling and the three different dissenting opinions. But at the end of the day, we know that the fight for clean water will continue.
Now, we contacted Governor Reynolds' office. She declined comment, as she said her spokesman said she's still reviewing the decision. Now, a few years back, you'll remember the Des Moines Water Works filed a lawsuit on the Raccoon River quality against drainage districts upstream. That effort the court ruled that drainage districts were immune from claims for injunctive relief. Now, Iowa CCI now is looking at other legal avenues to pursue this goal, and they're also, of course, looking at electing people to the State House that will work on this issue in the legislature. Dan, it's a lot there, but it's a very interesting story about the water that comes down the stream here in the Raccoon River.
Yeah, quite the legal precedent and something that attorneys are going to point to for years and even decades to come. Roger Riley reporting live outside of the Supreme Court building. Thank you, Roger.